Ever wondered how the banking process works? How do you navigate through the labyrinth of documents and procedures to access your financial needs? Well, today we dive into the heart of banking, stripping down the complex jargon and simplifying the process. E-banks operate in a world of documents. From the moment you open an account to when you apply for a loan or a credit card, paperwork is involved. These documents are not just pieces of paper, they are legal contracts, forming the basis of the relationship between you and your bank. Take the account opening form, for example. This document is a binding contract that sets out the terms and conditions of your relationship with the bank. It outlines your rights and responsibilities as a customer and the bank's obligations to you. Then there are the loan agreements. These documents detail the terms of your loan, including the interest rate, repayment schedule, and what happens if you can't make your payments. They are crucial in ensuring that both parties understand the terms of the loan and what is expected of them. But what about trust, you may ask? Well, trust forms the bedrock of the banking process. Banks hold your hard-earned money and personal information. They are entrusted with providing services that affect your financial health. Trust is a golden bond, a symbolic ribbon that ties you and your bank together. So there you have it, the banking process in a nutshell, a world of documents forming a legal framework and a bond of trust that underpins it all. Banking is not just about money, it's about relationships. It's about understanding and trust. It's about working together to achieve your financial goals. In the end, remember, every document you sign, every service you avail, every transaction you make is a stepping stone in your financial journey. So, stay informed, understand your rights and responsibilities, and always be aware of the fine print. After all, knowledge is power, especially when it comes to your finances.
Obligation or duty of a banker to customer. The special features of relationship between banker and customer cast certain obligation or duty on the banker. The first one, obligation to honor the checks. The deposits accepted by the bank are the liabilities which are repayable on demand from the customer. Therefore, the banker is under obligation to honor check drawn by the customer. Section 31 of the Negotiable Instruments Act 1881 lays down that the drawee of a check having sufficient funds of the drawer in his hands properly applicable to the payment must compensate the drawer for any loss or damage caused by such default. Now the next one is banker's lien. Generally, the lien is the right of the creditor to retain the possession of the goods and securities owned by the debtor until the debt is repaid. It is, however, does not vest the right to sell the goods, but the banker's lien has a wider connotation. That is, it is an implied pledge. The bank has the right to sell the items in its possession in the ordinary course of business and adjust the unpaid debt. Lien may be a general or particular lien. General lien empowers the bank to retain all the properties in its possession, but particular lien gives the right to retain the goods or property connected with the particular debt or particular property. Banker's general lien is not applicable to safe custody articles, documents, or money deposited for the purpose and securities valuable left through oversight. Now, the next one is mandate letter. The account holder alone has the right to operate his account with the bank. No person other than the account holder can order the bank to debit the account, but the account holder can give mandate or a power of attorney to another person to operate his account. A mandate is an authority given by the account holder in favor of a third person. This is issued by an account holder with the direction to his banker authorizing third person to operate the account. It is unstamped letter signed by the customer. A letter of mandate is generally issued for a short period as a temporary measure. Mandate letter should not be accepted from the limited companies. Now, a mandate will automatically lapse on death, insanity, insolvency, and bankruptcy of the account holder. The next one is power of attorney. It is a document executed by the donor or principal in favor of donee or agent to act on behalf of the former as per authority given in the document. The following points must be taken into consideration by the banker while accepting power of attorney issued by the customer. There are two types of power of attorney, that is specific power of attorney and general power of attorney. While the specific power of attorney is given for a specific purpose, the other one conveys many activities. Power to sign the check, stop payment, signing loan documents when given to the power of attorney holder. The donor is ultimately liable to pay the loan amount. It is a stamped document. The original power of attorney should be perused and a copy should be obtained and filled with the bank. The donor can withdraw or cancel the power of attorney at any time. Now, the next one is circumstances leading to the closure of accounts. The relationship between the banker and the customer is established by mutual agreement to open and operate the bank accounts, which may be terminated at any time by either party by closing such account. In fact, the banker-customer relationship imposes an implied obligation on the banker not to close the account of the customer except in extraordinary circumstances. In other words, the banker should carefully examine the issue before closing the customer's account, and unless there are justifiable reasons, it should not close the account of the customer. A bank may take initiative to close the account of an undesirable customer after giving proper notice for the following reasons. That is A. Frequent return of check for an insufficient balance, and B. Forgery or malpractice committed by the customer. However, a customer may close the account at any time. Now, loans and advances. Now, as stated, the bank deposits are used for lending or investment or both. In addition, bank handles purchases and sales of foreign currencies and also lends for imports or exports. The commercial banks lend money by way of overdraft, demand loans, cash credit, or by way of purchase or discounting of bills of exchange or hundis for the purpose of financing trade, commerce, industrial, or any other business activity. Lending by the bank is mostly against securities such as goods, book debts, land and buildings, livestock, share, securities, etc. When the advance is given against such security, it is termed as secured advance, and in cases where the advance is not backed by any security, it is classified as unsecured or clean advance. The next one is obligation to maintain secrecy of accounts. All the financial dealings of a person are maintained by the banker, which provides the true and correct state of financial affairs of the customer. If such financial dealings are known to others, the customer's reputation may be at loss, and therefore the law casts an obligation upon the banker to maintain utmost secrecy about the finances of his customer. The banker is under obligation not to discuss about the state of affairs of his customer to a third party, including the government or to the public in general. He should take utmost care to safeguard the secrecy, and no information should leak out from the book of accounts. Section 13 of the Banking Companies Acquisition and Transfer of Undertakings Act 1970 specially requires bankers to observe, except as otherwise required by law, the practices and customary usages amongst bankers, and in particular not to divulge any information relating to the affairs of the constituents except in the circumstances in which they are in accordance with law or practices and usages or appropriate for them to divulge such information. However, there is an exception, that is the disclosure of information required by law, and if the consent is given by the account holder, that is with the duties or obligations of the banker. Now, bankers' rights. There are 4 types of rights which a banker can exercise in the capacity as a banker. Right, the first one, right to exercise general lien. A lien is a right of a creditor to retain the possession of securities, goods, or any property belonging to the debtor until the debt is repaid. It is legal contract between two persons where one person retains the property of another as security for payment of a debt. In Halsbury's Law of England, it is stated as lien is in its primary sense a right in one man to retain that which is in his possession belonging to another until certain demand of a person in possession are satisfied. It is primary sense, it is given by law and not by contract. Then, a banker's lien on negotiable securities has been judicially defined as an implied pledge. In the absence of any understanding between the banker and customer, a banker can exercise lien on all bills received from a customer in the ordinary course of banking business. It should be noted that the lien extends only to negotiable instruments which come to the banker for collection purposes. Therefore, it can be inferred that when a customer avails loan from bank, the lien arises immediately on the general balance. The term general balance refers to all sums presently due and payable by the customer, whether on loan or overdraft or other credit facility. To exercise the right of lien, a separate agreement or document is not required, and hence it is understood that lien arises only by operation of law. Section 171 of Indian Contract Act 1872 confers the right of general lien on the bankers. Now, in order to exercise lien, the following requirements are to be fulfilled. That is, A. The property retained by the banker as a security must be with the banker in his capacity as a banker in the ordinary course of business, and B. There should not be any other agreement or entrustment inconsistent with the lien. Now C. Possession of the property must have been obtained lawfully. Now banker's lien is a general lien and is considered as an implied pledge. As per section 43, as per section 43 of the Negotiable Instruments Act, the banker can exercise lien over certain negotiable instruments in his custody such as bills, notes and checks, where the banker is considered as a holder of value up to the value where the lien exists and can realize them when due. Now, the next right of the banker is the right of set off. Set off is in the form of a cross claim which can be exercised by banker when a customer has money in the bank account and also owes to the bank in some other account. Then the banker can exercise his rights of lien to set off the money by way of adjustment of the accounts. Principles governing the set off are: the first one, the right to set off from various accounts of a single customer is based on principles of equity. The banker has to establish a definite and liquidated claim before exercising the right of set off. The claim that the bank seeks to set off should be in the nature of mutual debts and that should be due to the same parties. Now, in the case of money, right of lien and set off arises only in relation to the customer's money and does not apply to money paid under a mistake of fact. Since the banker exercises the right of set off as a general custom, the customer cannot claim injustice on the ground that at the time of opening of the account, the banker did not seek applicant's consent to exercise the claim. The right to set off is an automatic right and hence free from any kind of legal proceeding. The banker has the right to combine both the debit balance and the credit balance that exist in two different accounts in different branches in the name of the customer. The banker need not take prior written or express consent of the customer to exercise the right of set off. On the other statutory provision, if any, contrary to the right of set off, such provision would override the right of bankers. For example, in case of distribution of property, if there exists a statutory provision detailing the waterfall mechanism, then such a provision will take precedence over the banker's general lien. The bankers have a right to set off against all monies actually due. The very concept of a set off means adjusting what is due to somebody else against what is payable. In practical terms, the right to set off would be conferring upon the bank two kinds of right. Firstly, the banker can restrict the withdrawal right of the customer from the account maintained with the bank, and secondly, it also enables the banker to debit against the balance accrued that is due. Now, it should be noted that in case of joint account, the banker cannot exercise the right of set off against the debt due from one of the joint account holders because the bank cannot transfer money from the credit balance of one joint account to set off the debit balance of an individual account. However, if there is an express contract between both the parties specifying that one holder of the joint account can stand as guarantee for the debts taken by the other in personal capacity, then banker can exercise their right of set off against the joint account. The bankers have a right to combine one or more accounts of the same customer under their right to set off. Under the general English law, rights of banker to set off can be categorized as right of set off before insolvency and right of set off after insolvency, because in the event of insolvency, several laws come into force to determine the financial status of the party. Now, bank's right to set off and insolvency is considered under four conditions. That is, the first one, the contractual rights of set off will not survive the liquidation or bankruptcy of either creditor or debtor. The second one, under the general English law, rights of a banker to set off can be categorized as right of set off before insolvency and rights of set off after insolvency, because in the event of insolvency, several laws come into force to determine financial status of the party. The third one, in pre-insolvency stage, that is before the customer is declared to be insolvent, rights of set off includes set off of mutual debts and obligations by exercising the right of legal and equitable set off. And the fourth condition, after the commencement of insolvency proceedings commence, several mandatory provisions of law come into play to govern set-off proceedings, particularly with respect to contingent liabilities. The insolvency laws will prevail over right of set-off, that is a contractual right, and commencement of insolvency. Now the next right is banker's right of appropriation. The right of appropriation arises when a debtor has several debts with a creditor. Rules regarding appropriation are as follows. 1. General rules of appropriation. When a debtor owes more than one debt to a creditor, and when debtor makes payment indicating that the payment is to be applied to discharge a particular debt, the payment must be applied accordingly. In the absence of such indication, the creditor can appropriate the payment in his discretion to any lawful debt actually due and payable to him, whether its recovery is barred by law or limitation or not. The second one, the above principle of appropriation also applies to the loans obtained from bank when there are two or more debts due to a single customer. Generally, when both the principals and interest is due, any payment made should be first applied to appropriate the interest and thereafter to the principal amount, unless there is agreement to the contrary. Now, third, bank need not accept the payment on the condition proposed by the borrower, but when the banker accepts any condition of appropriation, the same has to be fulfilled. Now, the fourth, right of appropriation can be exercised only at the time of payment. The banker has to intimate the customer by ways of notice of its intent to appropriate the payments. Now, the fifth one, each credit entry is deemed to be appropriated against debit entries in chronological order, where a customer has a single overdraft account. Now the next right, the fourth right, that is right to charge interest, incidental charges, etc. Now A, every bank has the right to charge interest on the loans and advance to the customer at periodical intervals such as monthly, quarterly, semi-annually or annually. B, in addition to the interest levy, banks also have the right to levy commission and service charges for the services rendered and debit these charges from the customer's bank account. That is with the rights of the banker.
Gratitude for your company and support. Enjoyed it? Hit like, drop a comment, subscribe and ring that bell. Stay in the loop. Don't miss the action.